case will be Undivided Media versus City of Seattle.
May it please the court, my name is Jackson Maynard. I represent Brandy Cruz and Undivided Media on behalf of the Citizen Action Defense Fund. I'd like to reserve 2 minutes for my rebuttal. Under the Public Records Act, agencies are required to adopt and enforce reasonable rules that provide fullest assistance to requesters and the most timely possible action on requests. Here, the trial court wrongly found that an agency that had failed to enforce its own policies did not violate the Public Records Act. This decision should be reversed to avoid giving agencies a blank check to disregard their own policies and constructively deny requests. I'd like to begin first with the standards that the courts apply to public records claims as articulated in Can 2 and adopted by this court in CSA v. Bellevue School District. First, the Public Records Act must be liberally construed. The court considers the totality of the circumstances, and it's the city's burden to show that it acted reasonably in responding to the request. The court adopts an objective standard from the viewpoint of the requester. An administrative inconvenience is not an excuse. While an agency can request to produce documents in installments, it still must show reasonable diligence. And in a nutshell, that is the issue here, and the crux of the issue is that the city...
Would you agree that there's case law that states that violation of the city's internal policy does not necessarily create a cause of action regarding violation of the PRA?
Your Honor, the one case that the city relies on heavily, which is Joyce v. State DOC, is a Washington Supreme Court case, 2004. It is distinguishable. It is not a Public Records Act case. It deals with wrongful death tort claim and a jury instruction and whether or not policies were violated there. So it is very different in this circumstance in which the legislature has specifically under RCW.
I mean, regardless of what you're suggesting regarding the city's policies, I mean, the PRA, we have developed case law on what is it we consider regarding the violations that you're claiming here. So whether they violated the city's policy or not, we still look at whether their evidence supports a violation of the PRA, right?
Yes, Your Honor, it is a case-by-case analysis, factual specific, but the RCW 4256-100 requires the city to adopt and enforce those policies.
That's a different thing, though, isn't it, Counsel? I mean, what we're really talking about here, the claim is that the city didn't act with reasonable diligence to produce the information. I mean, that's the claim in a nutshell, right? And so the fact that the city has policies, well, that's a good thing. Whether they followed those policies or not, wouldn't that be evidence that could be presented to a finder of fact to determine whether they acted diligently or didn't act diligently, which is a different thing than saying it's a per se violation, right?
Your Honor, to be clear, it is evidence of diligence. It is required by the statute, but it is evidence of diligence, and the fact that the city failed, for instance, to follow its own, how it declares it's going to decide what a reasonable time estimate is.
And I'm not necessarily disagreeing with you. I'm talking about how you're phrasing the issue, right? So if their obligation is to act with reasonable diligence, they have a separate obligation to impose some sort of system, right, to be able to handle what's going on so that there's a way that they can take all these requests and in a reasonably diligent way deal with them. So there is that obligation. They have a system in place. Then the question is, did they act reasonably diligently, and is some evidence of that, whether they complied with their own internal policies and how they acted in providing the information?
So, Your Honor, we framed whether or not they complied with their policies as an adequate process claim. That was how it was framed. But there is some overlap because the policy...
Well, if you're saying that there's an adequate process, then you're challenging the sufficiency of their policy. You're not challenging whether they acted diligently.
I am... Your Honor, that is true. We are not challenging the policies. The issue in this case is they didn't follow the policies they had on the books, and because of that, they did not act reasonably. They can't establish that they acted reasonably.
That's evidence that they didn't act reasonably diligently.
Yes, Your Honor. And
That's different than, for example, cases to where as long as the city has these policies, the minute you point out they didn't comply with one of them, that's a PRA violation. Isn't that a little different?
Your Honor, it is a little different, and we're not making that sort of per se claim here. What we are saying is, in failing to follow the reasonable time estimate policy, section 5.32, where the public disclosure officer, the PDO, admitted that he did not use the 17 factors that are identified there. He created his own system, calendaring system, in which he lumped all of the requests in chronological order, estimated 3 per week, lumped my client's request at the end of that, and didn't even follow that system because.
And this was a summary judgment, right? So is what you're arguing that a reasonable trier of fact could determine that that evidence shows there was not reasonable diligence, and so it should not have been decided on summary judgment, and it needs to go back for a trier of fact to correct
I think
that?
it's two-part. I think the court failed to view that evidence as well as evidence regarding the providing fullest assistance rule that we've outlined in our brief and the failure of the city to follow that in the light most favorable to the plaintiff, and taking into account all of the standards in which, if there's any doubt that the requester, all of this is supposed to be resolved in favor, liberally construing the Public Records Act in favor
What
of
I'm hearing you saying is based on the city's own evidence that they've presented, which is Jager's testimony of this is how he goes about his business. He does it in a chronological manner, goes to the end of the line, and this is how many weeks it takes me to process it, even if I'm the only PDO. So even applying what he is saying, this is how he does it, that there's no explanation of why he picked November 10th or 9th.
Yes, Your Honor, I think if I understand your question, that's correct. The issue is this calendaring system process is not what's identified in the policy for how he is supposed to determine my client's, whether or not a reasonable time estimate for my client. He didn't allocate whether or not additional resources, either in the 90 other PDOs that were available at the city or under Section 5.23, the fact that he could have used non-PDO employees, if necessary, to provide a response. Again, this is a narrow request for one city council member on a single day in a 10-hour period and a few hundred documents, and it took them nearly 5 months to complete the request.
Correct me if I'm wrong, but in the record, it suggests that he was, aside from the one about a week in July, that he was gone for about 2 weeks in September, correct? And that the person who was covering him was a supervisor.
Yes, Your Honor. There's two issues with the alternate that they were required to have.
Right, so my question to you is this,
Yes, Your
according
Honor.
to the record, his supervisor, basically his own deposition was that she didn't really understand the job or know what to do. I don't see anything in the record to explain why that person was not properly trained to cover. That's what the person was.
I think again, it's the city's burden to show that was reasonable. There was an entire week when the PDO was out on some personal leave that they had no alternate whatsoever, which they were required to have. In conclusion, because the city failed to act with reasonable diligence, this court should reverse the ruling of the trial court and remand for consideration of penalties. Thank you.
May it please the court, my name is Dallas Lapierre on behalf of the city of Seattle. It is our position that the court below correctly reviewed the evidence in the record and correctly found summary judgment in favor of the city. The plaintiff's argument has been largely that a violation of city policy is a violation of the PRA per se.
Well, can we just go directly into the evidence that the city provided as to how they acted reasonably regarding fulfilling this request?
Absolutely, Your Honor.
The evidence that the city provided, mostly through Jager, was like, this is how I do it. I take things chronologically. When there's 2 of us, it takes about this many weeks. When there's 1 of us, it takes about this many weeks. Going by his own testimony, the city's evidence on this is what I do, I'm trying to understand where is the explanation of why he decided at that point in time that the second installment would not happen until November. Because based on his estimate, it should have been September.
Yes, Your Honor. Mr. Yeager initially said was that he looked at the policy. The policy does give factors that may affect a reasonable estimate of time. It says, conclude but are not limited to these following 7 factors. He said he considered those factors. Nothing under those factors rendered this particular request unusual or something that was going to require any additional time than a normal request. And so he looked at how many requests he currently had, how long he usually takes to get a number of requests done per week, and gave an estimate of what a normal request would be, and that's what he did.
But that, I guess you're not answering my question, because under his explanation, that gives you a reasonable estimate that's far earlier than November. So I'm trying to understand, where in the record has the city provided evidence as to why it's November? Because what I saw was his only explanation was, well, it was staffing issues.
That was part of it. There's 2 separate issues there. One is providing a reasonable estimate, which we believe he did. 2 is were they diligent in actually providing the records themselves. And it is not necessarily true that failing to meet that reasonable estimate is the same as being not diligent. And we believe here Mr. Yeager did provide the first tranche of documents on time and said it would take additional time to get the remaining documents.
So, counsel, with regard to the using due diligence, the reasonable diligence, the city chose to proceed by way of summary judgment rather than by way of a show cause trial. So, with regard to summary judgment, now we have to look at the evidence in the light most favorable to undivided, and we have to ask ourselves, could any reasonable trier of fact determine that this was not reasonable diligence?
And I think you're on the
Sounds to me like that's an issue for a fact finder, not an issue. It's a fact-specific inquiry. Don't you have to reasonableness in itself is something we almost never let be decided at summary judgment. So with the facts that have been presented here, why would we let this go at summary judgment?
Because the only evidence presented to show that there was not negligence in any way is that, 1, he violated city policy. The only evidence was that he did not violate policy in any way. There was an assertion
the
that
evidence was that there was a very finite period of time that was requested, that it wasn't a particularly large request, that it took 5 months, that he developed a system that he wanted to use that was contrary to the system that the policy put into place. So, isn't that enough evidence for it to go to a trier of fact? Because you would have to show that, viewing the evidence in a light most favorable to undivided, that no reasonable trier of fact could decide anything other than that this was reasonable diligence. That's a pretty tough standard.
it is, Your Honor. However, the problem is that while he's classifying it as evidence that he created his own method of doing it, the only evidence is his testimony of what he did. And his testimony was he complied with the policy.
But his testimony was how he does it. Aside from the policy, even his own description of how he does it, I'm trying to get from his estimate of the November date. And you're saying, well, it's just reasonable. That seems to be very conclusory, because based on how his estimate is, we don't get to the November date. I'm trying to understand that.
Because it is an estimate. It is estimated reasonably that it would take that long. It turns out this was an actually larger document.
You've had a number of questions that are trying to kind of bring things back to the summary judgment standard. Judge Bowman confirmed, this was a strategic choice by the city to proceed by way of summary judgment. The city carried the burden, the evidentiary burden, and undivided has the benefit of the reasonable inferences in their favor. I'm still struggling to understand how the evidence that you're discussing right now determines, or supports a determination as a matter of law as to reasonableness. Because we've got case law that says on summary judgment, conclusory statements are insufficient to carry one's burden.
I would agree. And the point I'm trying to make is all of the evidence here is that Mr. Yeager was diligent. There is no evidence that this was anything other than
Well, it's not
a
just
diligent
him,
response.
the city was diligent, right?
Correct.
There's the 2 weeks he was gone in September. The person who was covering him said she didn't know what she was doing.
She said she was providing adequate, reasonable estimates, but she was not doing anything beyond that. That is true. But the question comes back to...
How is that diligent? Having somebody to cover the job who didn't know what else to do.
She was just making sure the city was meeting their obligations under providing the reasonable estimate, Your Honor. That is what she was designed to do. That was the backup PDO's position.
So isn't that an issue of material fact for a fact finder to decide if that evidence from Dedman's deposition gets you over the hurdle with regard to reasonableness?
I do not believe so, because there was no evidence that that was not a reasonable reasonable
But
policy.
isn't the reason we don't decide reasonableness at summary judgment is because reasonableness is a wishy thing. People can take the same set of facts and reach different inferences from that same set of facts. And at the summary judgment stage, those inferences need to go in favor of the non-moving party, which here is undivided. I'm having a hard time understanding how it is, using that standard, that we can come to the conclusion that this trial court came to.
It's because if they had something where they had shown that the city had violated the policy, or that the city had done something that
You're arguing the opposite of what he was arguing. Whether they violated the policy or not is simply evidence as to whether they acted reasonably diligently.
Correct.
Here we have a small request that took 5 months to produce, and we have an explanation as to why that was the case, some of which might sound reasonable, some of which might sound reasonable to the ear of a trier of fact. But we're not at that stage. We're at summary judgment. So we look at it as if all of this evidence weighs in favor of undivided. And if we look at it that way, how can we say that no trier of fact could determine that this was unreasonable? It's just not computing with me.
Part of it is, I think, some of the uniqueness of the PRA. The other part of it is that there is this allegation, there's assertion that this was a small, simple request of just a couple hundred documents. And the truth is that this was nearly
Jaeger
1,000.
said it wasn't complex.
It wasn't complex, but it wasn't small. It was over 1,000 documents once he
The
started getting
city's
those
put
in.
forth that the reason why the second installment was what it was, he said, he didn't say because it was complex. He didn't say anything except for staffing issues. We have case law that says that's not sufficient. So wouldn't that support against you? Summary judgment, city's happy at summary judgment with these facts and these facts alone. If you say it's only staffing is the reason for delay, and we have case law says that's not sufficient,
The problem, Your Honor, is that not meeting that original estimate is not the same as not being diligent. The answer that staffing is the reason why it couldn't have been faster is not the same as saying staffing is the reason why it was not diligent.
isn't the question him deciding what the date is for the reasonable estimate regarding November to begin with?
I mean, if there isn't a requirement that the person provide a reasonable estimate, but the case law is very clear that we have cited that failing to meet that estimate is not the same thing as not being diligent. The estimate itself was given in compliance with city policy and with compliance with the PRA, was given within 5 days and appeared reasonable. Once he started getting the documents in, started realizing the actual number of those documents, he was not able to meet that particular deadline. He did provide the first set, I believe 500 documents, and had
Sounds like you're
273
trying to add
remaining.
information that Jaeger didn't testify to, right? Because the evidence of why it was November, all we have is it was staffing issues.
The only evidence of what he testified to in his deposition was why it wasn't faster, was that it was staffing issues, or why it was going to take the time it
Didn't
does.
Randy Cruz specifically ask, why is it so, why are you telling me the second estimate is November? And his response was staffing issues.
No. When she asked that question, there was no answer. That was one of the complaints that was made, that she did keep asking
that
questions, there was no
disputed?
answer. Now, was there a deposition testimony on that? Not anywhere in the record that I can find, Your Honor.
Are you saying that Jaeger didn't say it was staffing issues at some point in time?
No, I very much did say, he said one of the reasons why it took as long as it did was because of staffing issues.
And what was the other reason in the record? What did he
That
say?
it took long, it was just the number of documents it was themselves.
Where did he say that? Where in the record does he say that's why it was November?
And again, I'm trying to understand, Your Honor, maybe I'm misunderstanding your question. Is it why the original
No,
estimate?
that's what you're arguing, that the reason is because of the number. Where in the record did he said that's the reason why I estimated November?
Okay, I'm now understanding your question, Your Honor. I apologize. I was answering to why the total time took 128 days. If you're asking me where in the record does he say why the original estimate was?
November.
November? Yes, Your Honor. That comes down to where he says he looked at the request specifically and then gauged how much time it would take him to get to it. And based on the lack of other staffing, that was where the estimate came down to.
Thank you.
Counsel, I know you only have 2 minutes. Before you get started here, my question to you is, you've got sort of the flip side of this coin going on, right? If a finder of fact could, infer two reasonable outcomes from this same set of facts, then doesn't that mean that it goes back to a fact finder to make that determination? And is that what you're asking here? Are you asking for it to get sent back to go before a fact finder in a show cause trial, or are you asking for us to determine that no reasonable trier of fact could conclude anything other than that this was unreasonable?
Your Honor, we are here on a appeal from a summary judgment motion, so this court is empowered with a de novo review of the facts.
I
And
know that. I'm asking what you're asking for.
And so we're asking for this court to look at the facts in light of the burden, the fact that it is the city's burden to establish that they acted reasonably, and in light of the facts in the most way favorable towards the plaintiff, and rule in our favor here, remand the case back in light of that for a determination of penalties, fees, and costs if the court.
You're asking for us. You're asking for us to make a determination that that there was not reasonable diligence that was used, and the only issue to be resolved is the assessment of fees and penalties.
That is correct. And to address the earlier question.
Isn't that the reverse of what we were asking opposing counsel? Like, is reasonableness something that can be determined as a matter of law? Because you're asking for us to engage in de novo review and conclude that on this record, the only conclusion is that this was not reasonable diligence.
I think that is completely appropriate for this court to do, as it did in the CSA v. Bellevue school
We didn't do
district
that in
case.
CSA. CSA was a different posture. There was a show cause hearing. There was a trial. And the judge made findings after a trial. And so we were looking at it from that standpoint, not as a result of a summary judgment motion. And it was the same in, Rufin and all the cases that have come up here. Actually, I was the trial judge on Rufin, so I remember that one well. So it was the same. It often is the same posture. These, when we're talking about PRA questions, they rarely get decided on summary judgment for this very reason, right? It's all about reasonableness.
Your Honor, there were a number of cases that we did cite in the brief, and I can't bring them to mind right now, but that were resolved on summary judgment. And that is what we're asking the court to do here. And to address the question earlier, on page 126 of the clerk's papers, the question was, how do you determine when the first installment would be provided? This is to Mr. Yeager. He answered, entirely based on workload. We would request that the court reverse the trial court and remand for determination of penalties, fees, and costs. Thank you.
Thank you.
Thank you, counsel. Thank you both. We will allow counsel a moment to transition, and our final case on this morning's docket will be Fry versus North Shore Early Learning.